On the penalty...
But sir, finding price parallelism in one sort of sector based on the same set of circumstances and not finding it in another, it just sort of confuses the jurisprudence, and the reasoning seems a little all over the place, is just my point.
Price parallelism is only one of the dimensions. There are various other dimensions which stem from the behavior and what's the capacity utilization, whether the capacity utilization has been deliberately suppressed, whether they have met now and then to divide the market, and so on and so forth. So I think we leave it at that at this stage. The other is on the imposition of penalties. And what I have very clearly stated earlier, and the Commission is of that view, that it's a little too early to come out with very specific penalty guidelines at this stage. And we don't intend to do that in the near future. But yes, the penalties imposed in individual cases must adequately articulate the logic, the rationale, and the raison d'etre on the basis of which penalty has been imposed, whether it's high or low, and why it is so. So we'll continue to do that, which is what we regard as important, which is what COMPAT has also directed us to do in a number of cases. On the third point that you mentioned on the principles of natural justice, I think that is inbuilt into any quasi-judicial process, and we do our best to follow that. But let me also say that every now and then we find a tendency of the stakeholders and the legal community trying to game the system and make sure, because it's in nobody's interest when something is moving in a certain direction, it's not in their interests to get an order which is likely to be adverse from the Commission. So there's an attempt to game the system, and if we go along the whole route on that way, then we will probably never end up deciding cases, and we would then be in serious danger of becoming like civil courts, which is not the intention of the legislature, and that is why economic regulatory bodies of this kind, which will investigate and enforce, have been set up.
So, sir, in cases where the High Court and the Supreme Court may have upheld those appeals on that the principles of natural justice weren't followed, you would agree that there have been lapses in the past?
Well, High Courts don't really have normal jurisdiction in these matters, but people go in writs and so on, and then they sort of come back to us. But yes, if there is any matter in which the Supreme Court says that natural justice has been violated, then obviously that's the law of the land.
Okay. So the next issue I want to understand from you is the friction between intellectual property law and the competition law. The mandate of intellectual property law is to create monopolies, to secure innovation. The mandate of competition law is to break monopolies. How do you think going forward these two would converge, if at all? And you've had one instance of your jurisdiction being challenged in the Ericsson case, where the Delhi High Court, and you've appealed that matter, has told you not to come out with a final order. How do you see this pan out in the future?
Well, there is a certain amount of friction, as you said, between competition law and intellectual property. But even intellectual property, I mean, it encourages innovation. It wants companies to be more efficient. So in that sense, there is also a complementarity between the two provisions. And we come in, the competition law and the Commission come in, where there are clear-cut issues of competition and not specific issues of intellectual property. Where there are issues purely of intellectual property, its violation, its application, its process, then there are different authorities in the country where the parties are supposed to go to.
So I'm just trying to understand how would you sort of look at a monopoly or a patent and go about employing the principles of competition law in such a situation?
See, patent does not necessarily mean monopoly. So that's one point.
If I have it, I'd like to sort of use it, and you may see that as an abuse.
Secondly, even a monopolist, only if he's abusing his dominant position, then he comes into the ambit of competition law. So if his behavior...
But that's a thin line, sir, don't you think?
Well, that's what we are supposed to appraise and decide on. Okay. And parties are free to feel that we've been wrong and unfair in our judgment, for which there are various forums for appeal.
Sure, sir. I cannot not talk about control. I won't come to specific cases that have raised issues of control between SEBI and CCI, but are you in talks with SEBI, and would CCI approval be considered as a statutory approval necessary for an open offer?
See, each legislation has its own provisions. There is a certain provision in relation to control in the competition law. There is a separate provision on how control is to be viewed under the Securities and Exchange Board laws, and there would be provisions on control in other laws. So there is no one silver bullet so far as control is concerned. It's a matter of what eyes, what perspective you look at control. We look at it purely from the market or the competition point of view. SEBI presumably would look at it from the point of view of corporate governance, rights of minority shareholders, whether they are working according to the provisions of company law, and so on and so forth. So there will be nuances in the appreciation of control. And I don't think our talking to SEBI or their talking to us is going to resolve the matter, because there are separate provisions of the law.
No, sir,
so there have to be different perspectives.
Sure, sir. But if, say, for instance, SEBI gives a go-ahead and I'm waiting for a CCI approval, and SEBI has not considered or has not waited for CCI to give an approval for a merger control application, and for the purposes of takeover code, the open offer has been triggered, and I go and I wait for CCI approval to come in, but then there is an interest that I need to pay out to the tendering shareholders. So I'm trying to understand from that perspective, is CCI and SEBI talking?
Are you talking of issue of control? Are you talking of the different timelines under the competition law and the SEBI's law,
so
from which interest gets triggered?
Yeah, so control is a common thread, sir. So if SEBI doesn't consider CCI approval as a statutory approval required for its open offer to go ahead, the party gets penalized in that bargain.
I think on the control part, that dimension is different. But yes, on the timelines which we follow under our law and under our act, and what SEBI follows under its takeover regulations, there is an asymmetry in the timelines. I mean, we may take longer.
Right.
SEBI might decide it sooner, and the parties would then have to pay within a certain number of days to the public shareholders. If they don't, then the company will be required to pay interest on that. That's something which we are in talks with the Securities and Exchange Board. It's at the moment theoretical, because it hasn't really happened, I think, in any case. But maybe at some stage that needs to be looked at, and that will have to be looked at by SEBI, because it's part of their regulations, whereas our timelines are statutory. So we are not in a position to change those timelines unless Parliament chooses to amend the law.
Okay. Sir, it's been 2 years that we have had the merger control regulations in place. Regulators in different jurisdictions time and again come out with merger control guidelines that reflects the jurisprudence that has evolved over the last 2 or 3 years, and what's the thinking of the Competition Commission when it sort of examines the merger filings. Are you trying or are you attempting to do something similar here in India?
Well, 2 years is certainly not a very long period of time. It's relatively short. And I don't think our precedents and the cases that we have handled are sufficient to enable us to put out very straight-jacketed guidelines. So let me be honest and upfront that we are not going to put out merger guidelines in the near future. Maybe those will come 2 years, 3 years down the road. But what we are now starting, and this is going to start immediately, is going to be announced, is that we are open for pre-merger filing consultations on substantive issues, not just the procedural issues which we followed in the past. But now companies can engage with our officers on informal consultations on the merger substantive provisions.
And will this be a part of what everybody is saying, merger control guidelines will get amended? Is that where...
Not the merger control guidelines, the regulations are in the process. Well, this need not be a regulation, but this will be an announcement. Both the two of them may come together, but this is not really part of the regulation.
So are you also looking at, or the ministry is also looking at amending merger control regulations in some fashion?
In fact, we look at it every year to make sure that the regulatory burden on the corporates is not needless. It should conform to what is really our main requirements. So we did that in 2012, we did it in April 2013, and we shall shortly be doing it once again. So those should be in the public domain in the next week or 10 days.
Okay, and do you feel that this is the right time to probably look at the thresholds again? Basically, if you feel that a lot of deals are not coming before the Commission or do not require CCI approval because of higher thresholds, do you think it is a good time to look at the thresholds as well?
Thresholds is something which the government or the parliament can decide, but there is a notification which was issued when these guidelines, when the provisions of M&A were enforced in June 2011. There was a notification by which for acquisitions, a target enterprise was exempted up to 2,500 million rupees in terms of assets and 7,500 rupees in terms of turnover. Now the validity of that is 5 years. So that will end sometime in 2016.
Okay.
And that was consciously done so that industry gets used to this regime.
Right.
So I suppose there would be a good case from our point of view at least. I'm not sure what decision will be taken by the government then. But I think it will be a good case to not extend that notification, because in any case that then takes a lot of acquisitions out of the process of review by the market regulator.
Okay. So the last question I want to ask you is with regards to the certain the last question I want to ask you is about the certain seizure powers. The SEBI chairman recently was empowered with these, with the power to conduct dawn raids. Do you think that the CCI chairman also requires these powers?
The Act, as you know, provides for that in any case.
Yeah, but you need to go to the Chief
DG
Metropolitan
needs to go to the
Magistrate
and get a warrant and then do it.
Right.
The government had proposed, when they moved the amendment bill in Parliament, to give it to the chairperson. Now that process is not complete yet, and we'll soon have a new Parliament. So let's see what decision.
In your personal opinion, sir?
I think it would help, because then that can speed up the process and maybe ensure that things get done quickly without people getting to know about it.
But in any of the cases that you've examined so far or looked at so far, there haven't been any dawn raids, so to speak. So do you think that this is one power that is not being utilized enough by the Commission?
Well, we haven't, or the DG hasn't utilized it so far, but who knows?
All right. On that note, sir, thank you very much for your time.
Thank you.